Good afternoon. Thank you to all of you for joining us at UCLA Law School today. My name is Taimie Bryant. I'm a member of the UCLA Law faculty, where I am affiliated with the UCLA Health Law and Policy program. Please be aware that this event will be recorded and then a link will be posted on the Health Law and Policy program website. Please note also that there is an opportunity to submit questions for Kathryn Tucker, our speaker today. UCLA law student Kelly Conan will be keeping track of those questions and reducing redundancy, grouping questions for Kathryn's ease in answering at the end of Kathryn's presentation. Before I introduce Kathryn, I'd like to acknowledge those who have supported both this event and me as I have worked on this speaker series. First, I would like to acknowledge Professor Lindsay Wiley, who's the director of the UCLA Health Law and Policy program. I'd like to thank her for her enthusiasm for the speaker series and specific enthusiasm for each of our speakers. I would also like to acknowledge the UCLA Multidisciplinary Psychedelics Affinity Group, which exists throughout the campus and is composed of people throughout UCLA and some actually beyond who are working on psychedelics in their specialized fields. I'd also like to thank the Psychedelics Advocacy Network, notably Pamela Wood and Henry Passett, who have been my colleagues, but also my mentors and friends as I've developed different types of programming associated with my work in psychedelics. I would also like to thank Mili Lanu-Drivas, who is, Mili, you're going to need to advance that slide. It's not advancing for me. I'd like to thank Mili Lanu-Drivas, who is the faculty assistant associated with this series and this program. Really, she is the command central for all of this. She resolved problems before I knew we had those problems. So I greatly thank her. I also thank Kelly Conan, whom I briefly mentioned before. She has helped me with the previous event, and I trust that she will help us make most efficient use of the questions that you submit. I'd also like to thank the UCLA Law AV Department and the UCLA Law Information Systems Department and UCLA Law Events. All those departments are critical players in this speaker series. Thank you very much. Now I would like to introduce Kathryn. Kathryn is what we call a lawyer's lawyer. That phrase identifies a lawyer who earns profession-wide respect for tackling the most difficult of legal issues with intelligence, tenacity, and strategic skill. We will see evidence of this in the work she has been doing in the field of psychedelics. But by way of introduction, I'd like to speak briefly to her courageous work in the fields through which I first came to know of Kathryn. Kathryn spent years breaking multiple barriers to legal acceptance of medical aid in dying. Medical aid in dying refers to providing lawful access to lethal dose medications so that individuals can hasten death in the context of those individuals' irremediable suffering. Kathryn fought for recognition of the right to hasten death under US constitutional law. And then, when the US Supreme Court left the matter to individual states, Kathryn took on the challenges at each state level. Kathryn has worked on disability rights separately and also at the intersection of disability rights and medical aid in dying. She has argued that the requirement that individuals be able to self-administer the lethal dose violates the Americans with Disabilities Act if the law does not provide alternatives for those who cannot comply with that self-administration requirement. In all of these areas, Kathryn has pushed both legal and sociocultural envelopes. She advocates in courts, she advocates in legislatures, and she writes prolifically to reach beyond those arenas as well. She is a member of several professional organizations, including founding and board-level service for psychedelics organizations. Kathryn recognized early that legal access to psychedelics is very important. Not only does it intersect with her work in medical aid in dying, it also extends her career-long devotion to crafting and using law in the service of compassion and protection of individual rights. Kathryn will now be talking specifically about legal advocacy at the federal level to secure access to synthetic psilocybin. Thank you for joining us, Kathryn.
Thank you. Thank you so much. That was a very flattering and lovely introduction. And I did have as my very first slide a little introduction of myself, because not all hosts do such a long introduction. But suffice it to say, yes, I have spent now more than 30 years in advocacy that has been focused on protecting and expanding the rights of terminally ill. And I like to say that I've witnessed a lot of progress in that arena in a lot of different ways, which I won't have time to talk about today. But one thing that I'll comment is, despite a lot of progress, there was a notable gap in the palliative care toolbox, and that was for relief of non-physical suffering. And so when I started to see the quite remarkable clinical trial findings with psychedelic assisted therapy in this patient population, patients with advanced and terminal illness who were experiencing refractory, debilitating anxiety and depression, that these therapies were effective in relieving that non-physical suffering, I got very excited about becoming involved in efforts to make that therapy a palliative care tool available. And so that's what I'll be talking about in this presentation today. But I do want to just kind of cue this up with a little bit of a 30,000-foot overview. Psychedelic substances have been used across all time and all cultures in one way or another. And a really wonderful book, The Immortality Key, came out a couple years ago that does a great overview of that. And I certainly invite you to take a dive into that. A more recent and really entertaining read is the Harvard Psychedelic Club, which recounts the history of early research with psychedelics at Harvard when Richard Alpert and Timothy Leary were there. And that book, of course, covers the entire trajectory of the experimentation that was happening with the professors and the students, and how that all came to a sudden and screeching end when Leary and Alpert were fired. And then, of course, Richard Alpert went on to become launch into a spiritual journey of his own and became Ram Dass and wrote the really outstanding book, Be Here Now. So those are three books for you to enjoy, to take a deeper dive. But shortly after the Harvard debacle, and for a confluence of reasons, all psychedelic substances were put on Schedule 1 of the Federal Controlled Substances Act, and an era of prohibition ensued where there could not be access other than for research. Oh, I'm going the wrong way. Another great book to read that will kind of bring you current to the modern era is Michael Pollan's national bestseller, How to Change Your Mind, also depicted in a Netflix series. And what I think Michael does really nicely is make accessible the evolution of the modern era clinical trials, and a great overview of the populations likely to benefit and the efforts to open access. You'll get an introduction to the leading modern era researchers, healers, entrepreneurs, and advocates that are really shaping this new landscape. So why is there so much excitement? Because these substances are now much more widely understood to be offering potent tool to address a whole variety of mental health challenges. And I've listed a number of them for you. There are also substances that are researched and recognized to offer benefits for people who might be considered healthy normals for personal and or spiritual development. So, just last fall, I saw this study coming out for healthy normals, but offering persistent improvements in mental health and well-being. These were some of the benefits that were noted. And I think as you take a look at that slide, you can see that many people you know and love, and perhaps yourself, might enjoy some of those benefits. UCLA, who's hosting today's webinar, was part of the early pioneering research in psilocybin-assisted therapy for patients with advanced cancer. And Charlie Grobe, who's the first author on this study that I've provided you the site for, I understand he's speaking to you in March. This was a really important pilot study. And the findings were that it was feasible and safe to administer psilocybin to patients suffering anxiety and depression with late-stage cancer. That research has now been replicated at a host of other leading research institutes with similar and more sort of emphatic findings. And I particularly like this finding: immediate, substantial, and sustained relief from anxiety and depression at the end of life. This out of a study from NYU, very similar studies also out of Johns Hopkins. When you think about a new investigational drug being recognized to provide immediate, substantial, and sustained relief, that's a big deal. And that's why I got so excited to think that the patient population that I had focused my career could be the beneficiary of this. And particularly because, yes, we had done a good job in making strides to improve treatment and modality for physical pain and suffering, and expanding choice to allow more options such as medical aid in dying. But really, we hadn't seen a great tool for non-physical suffering. So this is just really riveting and exciting. Another population that's really important, that's showing incredible benefit from psychedelic-assisted therapy, are veterans. And the Heroic Hearts Project is just one of a host of veteran organizations that are now very involved in advocacy to open access to psychedelic-assisted therapy for veterans. And why is that so important? Suicide rates are very high in the veteran community, more than 20 per day. This has led many of these veteran groups, I've given you the name of a few additional here on this slide, to all come together under an umbrella that is called the Veteran Mental Health Leadership Coalition. And that coalition, which speaks, with great moral authority on behalf of the nation's veterans, has looked at this situation where veterans disabled by and potentially at risk of suicide from PTSD from their service are leaving the country they served to go to places where psychedelic assisted therapy is legal, Mexico, Peru, Jamaica among them. And the idea that veterans must leave the country they served is seen as morally unacceptable by these veteran groups. And that's a very potent message, whether you're in a courtroom or a state house or a legislative body. Another population where there's a lot of excitement about using psychedelic-assisted treatment for relief of a very serious condition, substance abuse disorder. As you know, there has been a tenacious, persistent, ravaging substance abuse problem, particularly with opioid addiction, with a lot of drug overdose deaths. And it appears that psychedelic assisted therapy can help people recover from that. If you are interested in a landscape overview of the modern research, an entity called Brain Futures did a nice job a couple of years ago publishing a roundup of all the different psychedelic compounds in modern era research, and then over 200 peer-reviewed studies are reviewed and summarized there. So I invite you to take a dive into that very comprehensive overview. This is a very useful development. The UC Berkeley Center for the Science of Psychedelics has now a new tool for patients, practitioners, and researchers to navigate the plethora of clinical trials with psychedelics. And podcasts about psychedelics abound. This is just one that I was on for Psychedelics Today, which is one of many. So there's tremendous interest and lots of discussions available to review. And many universities have now devoted a lot of new funding and interest among faculty and students to create these new centers. And these are just a few of them. So it's really exciting to see. And there's a specialty bar association. So for those of you who are lawyers and or law students, you might like to check out what's happening at the Psychedelic Bar Association, where those with specific interest in law and policy around psychedelics convene to talk about, write papers, take policy positions, etc. So let's turn to the nuts and bolts of the legal discussion that I'll dive in with you today. As mentioned, psychedelics were all swept onto Schedule 1 of the Controlled Substances Act, deemed to have, quote, no currently accepted medical use in treatment in the US. Now, even though that's the case for federal law, I will say that this excitement that I've alluded to has burgeoned to the point where states are not waiting on federal reform. And you may have noticed that Oregon jumped out front, as it has in other arenas of interesting health policy. You'll recall that Oregon was the first state to officially adopt a medical aid in dying statute called the Oregon Death with Dignity Act, the first among all 50 states to do that, and then subsequently followed by many other states, including California. But Oregon also jumped out front in adopting the Psilocybin Services Act. This was adopted via initiative, which is often how controversial policy measures become adopted into law, because legislators don't want to touch them. So direct democracy goes straight to the vote at the ballot box. And this initiative was adopted in 2020 and was a pioneering enactment. It was the first state law to do that. I'm not going to really talk about decriminalization measures. Those are different. You may be aware that everyone from Oakland to Ann Arbor to Cambridge have adopted decriminalization measures for various psychedelics in recent years. That's different than legalizing. And I want to disambiguate that. So Oregon legalized, it set up a highly regulatory program under the Oregon Health Authority. There's a lot to be said about the Oregon measure. I'll just touch on a couple of interesting aspects. First of all, no medical condition of any kind, no diagnosis is required. It is an adult use measure. Having said that, you may immediately think how that might be similar to cannabis, but one way it is starkly different is no one can go to a dispensary, as is the case with cannabis, purchase the product and take it for personal use. All use is limited to psilocybin service centers, where the consumer will be attended by a person called a facilitator. The facilitators have extremely limited qualifications in the sense that they need have only a high school diploma and a quantum of training approved by the Oregon Health Authority. That I think is really interesting when you start to think about administering psilocybin to the population that my work focuses on, which is patients with advanced and terminal illness. They should probably be seeing a much more highly trained professional, but I won't spend too much time talking about that. One other interesting aspect of Oregon Psilocybin Services Act is this service center restriction. One thing I want to flag for you, and of course, California is a hotbed of disability rights advocacy, and of course has been for some time. Whether that restriction poses a barrier to access that is unacceptable for severely disabled and or terminally ill people who receive most of their medical care at home. Home hospice visits are how many dying patients receive their end-of-life care. And shouldn't there be a reasonable accommodation for those patients so they can access psilocybin-assisted therapy? That's a question I've queued up and I'm very interested in. And if any of you are, you can circle with me afterwards. Other states are following in Oregon's footsteps. You may know Colorado adopted a similar but actually quite broader law a year or so later. Other efforts are emerging. I'll talk about California in a minute, but I do want to just flag for everyone, we do not know what the federal authority response will be. There seems to be some assumption in Oregon that the state legalization is sufficient, and certainly operations are up and running in Oregon, but there has been no position taken that I'm aware of by the feds vis-a-vis the enforcement of the CSA. And I do want to flag that you can look to the different arena of efforts to avoid opioid drug overdose deaths by opening so-called safe injection sites. Those efforts were the basis of federal adverse response, even though there was a laudable public health purpose of saving lives. The feds have stepped in and said drug-involved premises, defined in the crack house provision of the CSA, anyone involved is subject to federal law enforcement. So this could very much be how the feds respond to these service centers. Those are drug-involved premises. So we don't yet know, and I do like to flag, there are serious federal criminal risks of stepping outside the bounds of the Federal Controlled Substances Act. So what's going on in California? I know, there you are at UCLA and you have particular interest in California. This is a bill that went in December. This followed the veto of the adult use psilocybin bill that Governor Newsom vetoed. So that's something that's pending for consideration in the California State House. And then just yesterday, or the day before, was the introduction of Senate Bill 1012, the California Regulated Psychedelic Assisted Therapy Act. Really interesting, would address synthetic psilocybin. Now, one thing really getting in the weeds here, the Oregon Psilocybin Services Act legalizes the use of fungal psilocybin. So mushrooms are grown and consumed under the Oregon program. This bill in California is synthetic, and we'll talk more about synthetic a little bit later. So this is an interesting bill to watch and to maybe get involved with, since there you are in California. But again, this would create a state but not federal safe harbor. Without a federal safe harbor, obviously that presents some real challenges and barriers to participation, and particularly for the patient population that my work focuses on, people with advanced and life-threatening illness. As mentioned, most of those people will be receiving hospice services, hopefully. I mean, one of the good improvements of modern era medical care is the emergence of hospice as an important support to patients addressing terminal illness. And it's a really important benefit. It is a federal Medicare benefit. And yet, obviously, federal Medicare benefits are not going to apply or acknowledge and permit the use of a federally prohibited controlled substance. Also, providers holding DEA registrations, which are basically, necessary for the practice of medicine, would be at risk. Those registrants cannot violate the terms of their DEA registration by violating federal controlled substances law. So this is problematic. Okay, turning then to, what can be done. As I was working, I did work on the enactment of the Oregon Psilocybin Services Act, and when I was pondering the reality that even if we were successful in enacting it, the federal exposure would remain, I cast about, as you will sometimes be called upon to do as lawyers, to try to think of a creative way to find a federal safe harbor. And I started to look into right to try laws. I really did not know much about them before I embarked into this kind of landscape survey for federal safe harbor. But as I started to look at these laws, I became really interested in them, and they are worthy of your attention. Some of you may remember the Abigail Alliance litigation that is really what was the catalyst. And I do want to say, for those of you that are law students or starting your careers, having an appreciation of how litigation can catalyze legislation is something to occupy some of your interest. And I think this is a great example. So I'll just spend a minute reminding everyone that Abigail Burroughs was a young woman dying of cancer. Her father was desperate to get her access to experimental drugs. And he hoped to extend his daughter's life by doing that. And he went into court on a constitutional claim that a dying patient had a federal constitutional right to access investigational drugs under the Due Process Clause. And that case ended in the DC Circuit with a rejection of the claim. So I believe it was followed by a rejected cert petition, and that was the end of the road for trying to get relief through that litigation strategy. However, that organization, the Abigail Alliance, that had been kind of built up around litigation, pivoted and went into both state and federal legislatures with a legislative fix. And that is what became what you can call the Right to Try movement that really swept the country in a firestorm in the last decade. And a supermajority of states and the federal Congress have all adopted right to try statutes. And what these basically say is that dying patients don't have the time to wait for the long, slow process of new drug approval to wend its way to completion. So certain otherwise prohibited drugs should be accessible in certain situations for certain populations. And we'll talk about who those patients and drugs are. Here are the eligible patients. So as you can see, this would encompass both veterans at risk of suicide, because life-threatening disease is a broader term than terminal disease, and it would encompass patients with terminal illness. And these are the fairly simple requirements for patients to be deemed eligible. Oh, I've gone the wrong way. And what are the requirements for a drug to be deemed an eligible investigational drug? Also quite simple. And you can put a check mark next to each of these as regards psilocybin, completed a phase 1 clinical trial, not yet approved, remains under investigation. So you can imagine my excitement to see how Right to Try seemed to neatly fit our objective. So we began to develop an advocacy vehicle. I started working with an integrative oncology clinic in Seattle, the Advanced Integrative Medical Science Institute, and its director of palliative care, Dr. Sunil Agarwal, who is a highly skilled hospice palliative care physician. And he believed that some of his dying cancer patients would benefit from psilocybin-assisted therapy. He invited a few of his patients to consider working with him to pursue access. They agreed, and they became the parties who we approached DEA on behalf of to find out how it would accommodate Right to Try. It appeared that the DEA had never heard about or had any interest in Right to Try law, and it refused flat out to accommodate it. So that took us right into the Ninth Circuit. Some of you legal eagles will be saying, well, how did you go right into the Ninth Circuit? And it's kind of like a chutes and ladders where you get to jump over the district court if what you have is a federal agency denying access. So that took us right into the Ninth Circuit. And the case that we now refer to as Ames 1 was a petition for review in the Ninth Circuit challenging the DEA denial to accommodate duly enacted state and federal Right to Try law. We had a lot of amici, and again, for those of you that are law students or advocates, you know that it's great to see robust friend of the court support for the position that you are advancing on behalf of your client. These are the amici who came in, and I think you can join me in sort of marveling at the breadth and range of these amici. It's unusual in my experience to see a cohort of states come in on behalf of a private party litigant, but we did see 8 states led by the state of Washington, and joined by red and blue states from across the country to step up and say that it is the domain of states to be the primary regulators of the practice of medicine. And that is another really interesting case that many of you may have read and studied in law school. And we know that because a relatively recent SCOTUS decision in the now famous case known as Oregon versus Ashcroft-Gonzalez, you may remember, was the effort by then Attorney General John Ashcroft to essentially nullify the Oregon Death with Dignity Act by issuing a directive that said any physician who participated under the Oregon Death with Dignity Act would be at risk of loss of licensure and violation of the Federal Controlled Substances Act. So when that state was litigated, the question of whether the state versus the federal government has primary responsibility for the regulation of the practice of medicine, was in question. And the finding at every level, district court, Ninth Circuit, and SCOTUS, was that it is the states. So that brings this issue into interest for states. We had the Cato Institute and the ACLU on the same side as amici supporting petitioners. That's fairly unusual. They're often on opposite sides. We saw a lot of end-of-life advocates. We saw the modern era researchers and a cohort of clinicians, law professors, and bioethicists all came in support of the right to try argument. And we simply said, RTT is the law of the land. For those of you that want to get really deep in the weeds, the right to try federal legislation amended the Food, Drug, and Cosmetic Act, which is superior to the Controlled Substances Act. So the fact that the RTT landed as part of the FDCA makes the CSA need to respect it, and the DEA implements the CSA, and it is statutorily obligated to harmonize those statutes. The additional argument, of course, that the DEA's scope of authority is limited to effectuating controls against diversion, and it is not empowered to make determinations regarding practice of medicine. In a nutshell, those were the arguments that we made in the Ninth Circuit in Ames 1. The DEA, as it is wont to do, spent most of its attention trying to just say, nothing to see here, and characterizing its rejection of our request as not final agency action. So if any of you on this webinar are Administrative Procedure Act geeks, or if you're still law students and you're thinking you're not going to pay that much attention when you study the APA, many good reasons to pay attention and do so, because when a federal agency takes action adverse to your client, a threshold question will be, was the agency action sufficiently final that a court can review it? And what the agency will often want to do is weasel out of judicial review and say, our decision wasn't final. And it did that here. To the extent that the DEA reached the merits, it basically said that forbidding use by dying patients would further the objectives to conquer drug abuse. And it really seemed sort of patently ridiculous, particularly because this would be a dying patient receiving psilocybin-assisted therapy in the context of the doctor-patient relationship. It just seemed patently ludicrous. So there we were in the Ninth Circuit, and the court, as it often does, deferred to the agency position that it was not a sufficiently final determination. And we got thrown out. There was no reaching of the merits. So the DEA might have hoped we would just go away, but we pivoted really in mid-air, and we immediately did two things. We went back to the agency and said, well, if that wasn't your final action, please give us your final action so that we can return to court if needed and reach the merits. What happened there was the agency said the same thing it said the first time, which kind of suggests its argument of lack of finality was not quite honest. And it said exactly the same thing. So the good news is it said it in a sufficiently final way that matter was queued up to go to court to reach the merits. We did put that on hold temporarily, and I'm going to tell you why. But first, I want to tell you about this. And again, speaking to how litigation can galvanize and catalyze legislation, we saw the introduction of a bipartisan, bicameral bill in the federal Congress called the Right to Try Clarification Act. Super short, super simple. Everyone who is a citizen activist should mobilize in support of this with your federal electeds. And if you have advocacy groups you're involved with, please invite their support. It really would just simply be the federal Congress clarifying beyond any doubt that Schedule I substances are within the scope of right to try. There really isn't a viable argument to the contrary, but this would eliminate even a ludicrous fringe argument. So that's worth supporting. But we did open another front in the battle. And again, assuming I'm speaking largely to law students, you will often have the opportunity to kind of think creatively about how to get from point A to point B. And so here, when we got thrown out in Ames 1, we not only went back to elicit final agency action on the merits of the RTT, but contemporaneously, we decided to file a petition to reschedule psilocybin. Now, one of the interesting things, if you bother yourself to go and read any of the DOJ briefing in Ames 1 for the real nerds, or the decision in Ames 1, you'll see reference to DEA suggesting that maybe what petitioners should do is petition for rescheduling. So we took the bait, we took the DEA at its word, and we filed that petition. And that led to its own agency proceeding where the agency denied the petition. And we filed an appeal there. And that's the case we refer to as Ames 3. We put Ames 2 on hold, the right to try matter, because we felt that if we were successful in Ames 3 on the rescheduling, that we might not need to litigate Ames 2 to completion, because guess what? If psilocybin was rescheduled from Schedule 1 to Schedule 2, which is what we requested, smallest bite of the apple, then Dr. Agarwal would be able to access it for therapeutic use with his patients. And so we would have achieved our objective. So what happened here on the rescheduling petition? Well, as previously mentioned, DEA is an agency with law enforcement duty. It does not have medical and scientific expertise. When a rescheduling petition is received by the DEA, it has a statutory duty to send that petition to the agencies with medical and scientific expertise. And that is over to the HHS, which is delegated to the FDA. That didn't happen here. That's a big problem for DEA. And it applied an erroneous test to the petition. That case was argued in front of the Ninth Circuit in October, and the petition was granted. So there was only 1 week that elapsed between the hearing and the decision. One of the Ames 1 panel judges was on the panel in Ames 3, Judge Ikuda. So she knew the backdrop of what had gone on. And I think that may have been part of what allowed such a prompt decision. It was a win for petitioners. And for all of you that are practicing lawyers, you know, we celebrate every win, large or small, because they're so hard to achieve. It was a win, petition granted. However, petitioners would have liked more direction to the agency. It was a vacate and remand, but as you may have sensed here, the DEA is all about obstruction and delay. And so we would have liked clearer guardrails on what would happen on remand. When the Ninth Circuit decided Ames 3, the stay on Ames 2 came to an end. So we notified the Ames 2 court of the Ames 3 ruling, and we're now back in the Ninth Circuit. A briefing schedule was put in place, and Ames 2 is moving forward. In Ames 2, and again, for those of you who are Administrative Procedure Act nerds, you know and love the APA, and you know that when an agency is going to make a decision, it has to set forth reasons for its decision. It has to consider the problem that was identified in the petition, and it has to provide a reasonable explanation why the relief that was requested wasn't granted, and particularly where the petitioner had pointed to clear precedents for granting the requested relief. And, I'm not going to take a deep dive into all of the precedents that we cited to the agency, but they included these that I've given you in these bullet points. And for the APA, for the DEA to have failed to do any of this, well, these are multiple failures. And that's what we'll be talking about in our brief, which is due tomorrow. What we'll be asking for is a vacate and remand. And again, remembering what can a federal court do when an agency has failed in its duty to conduct itself properly under the APA, well, the relief is vacate and remand. And that can feel like less than satisfying, because of course, as noted in Ames 3, now there has been a vacate and remand. But what is the agency doing? It may just be doing more delay, which is really frustrating. What should happen here, and if we get a remand in Ames 2, the DEA ought promptly create a path to access pursuant to the RTT. And look, the agency has a lot of tools at its discretion. So it could grant a waiver for RTT access. It could issue a decision that no registration is necessary. It could require a memorandum of understanding that relates to diversion controls and security. It could create a special form of registration. So, the point is, DEA has a lot of ways to create this pathway. Its duty and responsibility is to do so. So we hope that will happen, and promptly. And again, here's another really interesting thing to notice. The Ames litigation has now stimulated a second bipartisan and bicameral bill in the federal Congress, also worthy of your attention and support. 4 drugs on Schedule 1 that have received breakthrough therapy status, which includes psilocybin, that would trigger a transfer to Schedule 2. That would take the DEA out of the position to logjam as it has done here. And with the movement from Schedule 1 to Schedule 2, that would make the drug much easier and less expensive to research. It would enable access by those with life-threatening conditions. And I see I've given you a link to a recent article talking about that act. And so that's also very much worthy of your support. So hopefully that is my last slide. If any of you have reason to reach out to me, there I've given you my email. You are also invited to follow this work. I post about it on my LinkedIn page if you'd like to connect with me on that platform. And then now I'm very happy to participate in questions and discussion if there are any. And I'm happy to also stop my screen share if that's appropriate at this juncture.
Thank
Thank you,
you.
Kathryn.
Thank you so much, Kathryn.
Kelly,
Thank you
do
so
you
very
see
much.
any questions?
Yes, can everyone hear me?
Yes.
Perfect. Thank you so much for that wonderful presentation. It's so inspiring as a law student to see people in the space who are making changes and taking risks and having creative approaches. So it's very important to see that and hear that. Thank you so much for sharing and with your time. Some questions that I've seen that I also came up some with myself, some coming up with for myself. With Oregon leading in psychedelic law, with them
So sorry,
taking
Kelly, you're breaking
the
up.
first-
I'm hearing like only every third word.
Let's see. Is this better?
Yes, slightly. I know.
Okay.
Headphones. Try that.
Oh, headphones can be, yeah, such an issue. But so with Oregon leading a lot of the developments we're seeing in the space of law, is there anything that you've noticed about Oregon's approach that other states should adopt or ways to improve Oregon's approach to make these services more accessible to people who need them?
Yeah, really, still really hard to hear you. But I think if I understood anything in Oregon's law that should be avoided elsewhere, was that the gist of the question? Yeah, I mean, I think as mentioned, the restriction to service centers is problematic. For people with disabilities and people with terminal illness, that is a barrier to access that may be insurmountable. So I am aware that in the Colorado measure, that restriction is not present. And I think that's an incremental improvement. So yes, I think you can look at what happened in Oregon and find ways to improve it. And again, you know, Oregon was a first go round, and a lot of times it's necessary to have experimentation. This is the whole benefit of having 50 states and what the Supreme Court refers to as experimentation in the laboratory of the states. So I think we are seeing improvements over Oregon in these next measures.
Wonderful, thank you. Our next question comes from Christine Altwell, who is a guest on this.
Yeah, again, it's the same thing. I can barely
And
hear you. Do you want to type the question in the chat? Because I could read it. It's really hard to hear.
okay. Question has just been entered in the chat. It should be.
Yeah, you know, something I'm not really that aware of that particular bill, but I appreciate that someone raised it. Yes, this is exactly the kind of thing that would be useful. And it reminds me, you know, in the cannabis context, there was the same problem, obviously, because cannabis is on Schedule 1. And at one point, there was a policy position adopted at DOJ that where states had legalized and regulated, there would be a position of restraint. We don't see such a policy position adopted yet, to my knowledge, by DOJ. That would be one way to create some form of safe harbor, but another way would be an actual federal bill that would create that kind of safe harbor. So yes, I think creative thinking about how do we create federal safe harbor is necessary.
Thank you. I think there is another question in the chat as well.
I am not seeing it.
Hi, Kathryn. The
Can you hear
question
me?
is regarding decriminalization versus legalization. What are the largest differences in practice in addition to what you mentioned about public dispensaries?
Yeah, I mean, the decriminalization is where the existing law, the penalty for violation is reduced. So it doesn't make the substance legal. It doesn't regulate the access to the substance or create any sort of regulatory regime like you see under the Oregon or Colorado measures, where, for example, an agency of the state it is involved in setting up the training that's required and then licensing the facilitators, the service centers, the manufacturers. That is all what happens under a state legalization program. And it's quite different than just the decriminalization. And then I see one of my colleagues is on here over in the Q&A. Yeah, I mean, Gaetano is asking about how advocacy groups in states, including New Jersey, can advance RTT efforts. Look, I mean, I think throwing support in both the RTT Clarification Act and the Breakthrough Therapies Act, those are worth doing. So I think that's important. And staying creative on like this visions introduction, you know, there may be many ways to create federal safe harbor. And a lot of creative thinkers can bring their thoughts forward for that. Number one priority for public education. Yeah, I mean, I think that, you know, Michael Pollan's book did a tremendous service in demystifying and starting to address kind of the stigma of psychedelics. And I love to recommend that everybody can pick up that bestseller and educate themselves. And I think, you know, the kind of takeaway that I had as a layperson in reading his book is that these substances have an unusual ability to help a person reset. And so for people who might be in some kind of a cyclical addiction, cyclical depression, they're in a frame of mind where they cannot step outside of that problem, that the experience of psychedelic assisted therapy kind of breaks out and lets a reset happen. And that's fairly understandable, I think, to people. And that's kind of the takeaway that I took from some of these discussions that Michael Pollan shared. What would be the most powerful next step to take place in the legal field? Well, look, I think rescheduling can and should happen. And we did just prevail in our rescheduling action against the DEA. It's possible that the DEA, that now that it's been remanded, will begin that important process of starting the rulemaking to cause that rescheduling. And I like to hope and be optimistic that that's happening.
Kathryn, can you hear me?
Yep.
I'm sorry, we had some kind of technical difficulty in my office, but I wanted to follow up with a question. So I wonder if you could speak a little bit more to the
I really can only hear every third word.
I'm gonna type it into chat.
Yeah.
And also reschedule to, what is it reschedule to, does it give doctor? Is it limited to, providing a substance with a particular protocol, under certain kinds of conditions? So how detailed is the paperwork?
Yeah, I can't hear. Here we go. Is this, what does rescheduling look? Read the question before answering. Yeah. So what does rescheduling to Schedule 2 look like? What does it give the ability to do? And is there a particular protocol? So as advocates, we decided to take the smallest bite at the apple and to make the smallest ask. So our ask was for movement from Schedule 1 to Schedule 2. And that was a strategic call that in making the smallest ask, we might maximize the chance of success. There are certainly others who have suggested, and when I say others, I mean researchers, including, Matthew Johnson, who's now the head of the clinical trials program of psychedelics at Johns Hopkins University, have suggested placement lower than Schedule 2. But we asked for Schedule 2 as a strategic call. Schedule 2 leaves the substance with very severe restrictions, but it would be accessible for medicinal use in the care of a physician. And so, Dr. Agarwal, for example, holds a DEA registration for substances on Schedule 2. And it's a very closely regulated schedule with a lot of security and diversion control measures. But it would have enabled Dr. Agarwal and any, palliative care physician like him across the country treating dying patients who have anxiety and depression related to their terminal diagnosis to be treated. And so, for our purposes, Schedule 2 placement would be sufficient. But, really, when you petition for rescheduling, you're asking the agency first to comply with its statutory duty to ask the FDA for a medical and scientific evaluation of whether rescheduling makes sense. Now, we already know here what the FDA would say. How do we know that? It has twice granted breakthrough status. Breakthrough status is only granted when the FDA determines that a new drug has the potential beyond the benefit of an existing drug. So we already know the FDA has said that twice with regard to psilocybin. So the DEA needed to make that referral to FDA. The FDA would have, consistent with its breakthrough designation, responded that, yes, this is an important and exciting, promising investigational drug. And that would have allowed the rescheduling proceedings to get underway, at which point others who want to contribute in that rulemaking to argue for a different placement, Schedule 3, Schedule 4, would have been able to bring forward those arguments and evidence. But we haven't gotten there yet because the DEA didn't refer to FDA and didn't open a rulemaking about rescheduling. So, very frustrating. Okay, so should I just be taking a look now at the chat? Breakthrough therapy, if the Breakthrough Therapy Act is adopted, there is a mechanism for an automatic transfer from Schedule 1 to Schedule 2. And that's correct. You would not be, as we have been, in the need to go to the DEA, which I think, sadly, this case exemplifies how slowly a federal agency can move, and how painstakingly long the process to get any relief from a federal agency. Next question. Yeah, I mean, I think there's a lot of chatter. The question is cannabis rescheduling. People are saying it might happen as early as March of 2024. Will this have any impact on psychedelics rescheduling? I think that's a really interesting topic of discussion. Cannabis rescheduling efforts have been going on for more than 50 years. And there have been multiple petitions to reschedule, and none of them have been successful. It does seem like that logjam is finally breaking. And I too have seen these suggestions that it's just around the corner. Maybe it will impact the psychedelics rescheduling. I mean, maybe the lesson will be learned that DEA obstructing rescheduling has harmed patients, and that kind of conduct will not be permitted going forward. I would love if that were an upshot of the whole debacle with how long it's taken to move on cannabis rescheduling. And I think that's all I am seeing in here. Feel free, I don't know, Kelly, I couldn't tell if my slides were actually displaying. Were they during the talk? Okay.
Yes,
But
they
feel
were
free,
very,
to make
yeah.
the slides available to anyone who wants them. And yeah, it's been a real pleasure to be with you. And if there are no more questions, I will let everyone get on to their busy day.
Thanks. This has been such a privilege to have you here speaking with us. We greatly appreciate it. Thank you so much, Kathryn.
Such a pleasure. Thank you all. Take good care.
Thank you, Kathryn.